Yeah, good morning. Um, Yesterday we spoke about the whole issue of the commercialization of religion, and I was in a bad place. I'm rural now, and somebody asked, "Where are you?" My answer is simple: I'm where a man cannot be without his wife. Okay, but then yesterday's recording didn't come out well. But the point I was trying to make was the the whole issue of commercialization of religion and how every time we bring the issues up, people think it's because we stand to gain from the process. We have no gain except to see our children and grandchildren and great grandchildren practice their faith in peace. So yesterday we spoke about the commercialization of religion. That what was quite disturbing is, though the Civil Rights Commission set out to investigate the commercialization of religion, and as their case studies, they used consultation fees for preachers. What they conveniently allowed to go under the radar was the fact that there were active complaints by the Christian community on the whole issue of halal. Halal is a 45 billion rand industry, and several Christian groups have complained to the Civil Rights Commission that we are made to pay for an Islamic religious observation. It would never matter to us what food we are served in restaurants and supermarkets. But then since April last year, 2018, when the report went public, the Civil Rights Commission committed to investigate, but have done nothing about that. Their lawyers had the documentation. And whereas they exist for the protection and the promotion of religious rights, they did nothing to protect the Christians' religious rights in this regard. As a matter of fact, they absolve themselves of all responsibility, referring the Christian community directly to the consumer board. And what is interesting is, whereas in this instance, where there was a valid complaint, they sidestepped the issue, referring the Christian community directly to the consumer councils and all that. In a lot of other issues, the violation of human rights, they didn't have the decency to refer the Christians directly to the Human Rights Commission, to the Equality Court and all that. So there's a serious bias, but that's not what I want to talk about today. Today, I promised to talk about Parliament and its recommendation to the Civil Rights Commission. What a lot of South Africans don't know is, this matter of the regulation of religion has already come before Parliament. In 2017, when the Civil Rights Commission submitted their very shabby, I looked at them, I'm a researcher. Oh, yeah, that report, we can make it available to anyone who wants it. It's a disgrace to every work of research. When they submitted their report to Parliament, Parliament rejected it. And the Civil Rights Commission, the erstwhile, the ex-chairperson, were so infuriated and disgusted with Parliament, the COGDA portfolio committee at Parliament, that they threatened to take Parliament to the Constitutional Court. I still have to check how far that process is. It's been 2 years. That means nothing came of it. But here is the reason regulation of religion will never happen in South Africa. Here is the reason that the likes of Reverend McCoy and company are just chasing a pie in the sky. And that is the reason they've been trying to plead with them to come to their senses instead of disgracing themselves further. Parliament found three glaring weaknesses with the Civil Rights Commission's recommendation. Don't forget, the Civil Rights Commission is recommending that the CRL Rights Act that birthed them, that created them, be revised to give them power. As a matter of fact, in subsequent meetings, they wanted power, and I'm quoting them verbatim, equal to or greater than the public protector. They wanted to enforce. They want to enforce religious compliance. They want to have the power to license and to close churches. They have the power to, they want the power to actually be a quasi minister of religion, whereby they'll sit there through their multi-faith institutions called the peer review councils. They want every preacher to come before them and prove that they should be preaching the gospel. But now, whereas we know that Jesus calls his ministers, and whereas we know that religion falls within the category of a philosophy, they were subjecting, and that's what Remy Kuri and Musasona are promoting. They're subjecting the selection of preachers to people outside the Christian faith. And that's what it's all about. Ray and Moss are saying, it's okay, there's nothing wrong with a panel which has a witch doctor, which has a Scientologist, which has a Muslim and a Hindu being part of the decision-making process regarding who should be a preacher, who's supposed to be not. I mean that's laughable. But now, they also were suggesting the Civil Rights Commission that the Constitution be amended to allow that to happen. You'd be limiting substantially religious rights, rights of association, rights to conscience. Now, Parliament said 3 things about that report. They said that report, the recommendations were unworkable. There's a parliamentary report on that. They said what the Civil Rights Commission is recommending is unworkable, because Parliament was of the opinion that we even say, Parliament is of the opinion that enough law enforcement agencies exist to deal with every complaint that the Civil Rights Commission had about religion, if there was ever any valid complaint against religion. I saw this documentary last night on Checkpoint, is it Checkpoint? About this man who's alleged to have raped women in church. And as it is, the trial continues. We're looking at the Omotoso case, the trial continues. We're looking at the Bushiri case, the trial continues. We're looking at a lot of other cases around the country. That means we have enough law enforcement agencies to deal with any issue of criminal behavior, not only in churches, but across society. So they said it's unworkable. You want to introduce a different level of bureaucracy. That means the Civil Rights Commission, for their recommendations to work, government had to set up extra agencies to deal specifically with religious crimes. Because one question I asked a very pro-religious regulation proponent was, before regulation, if a pastor is alleged to have raped women in the church, we call the cops. If we go with a recommendation for regulation because preachers are allegedly raping women in church, please tell me, in the post-regulation era, let's say we regulate religion now, when a preacher rapes a woman in church, how differently are we going to deal with that matter? Okay, second example. If a so-called foreigner, a Chinese preacher comes, those are foreigners. Now Zambians and Zimbabweans and Nigerians and Ghanaians are not foreigners. That one was set in our heads. No African is a foreigner in Africa. If a Chinese preacher comes into South Africa illegally, prior to regulation, how do you deal with it? And he says, no, of course, we raise the matter up with internal affairs, home affairs. And then I said, fine, but then after regulation, if we successfully regulate religion, how different are you going to treat that matter? No different. Right now, the issue of the Gupta citizenship is not the religious issue. That shows that all these matters should be dealt with holistically and objectively. Whether people are religious, the Guptas are Hindus, and they were given citizenship illegally. So how were you supposed to deal with that? Reverse the decision or regulate Hinduism? So the proponents of regulation don't understand how unworkable their suggestions are. But the second aspect is, Parliament says your recommendations are unnecessary. That means they have not built enough case for change. Laws can be changed. We're in the process of changing the Constitution to allow for the expropriation of land without compensation. But a case was built, and it's a pity these guys have not worked for government. We worked for government. A case was built, it was so formidable that it necessitated the amendment of the Constitution. So Parliament says, none of the recommendations that Civil Rights Commission has brought with us are compelling enough a case for a change of the constitution. That's a drastic step and a change of the law. So not only did they find the recommendations unworkable, they would never work. The lawmaker, the state has three agencies. There are three agencies, three legs to the state. That's parliament, the legislature, the lawmakers. And after they make laws, they pass the laws to the judiciary to adjudicate over. Those are the courts. But then the judiciary and the parliament are not running the country. The executive is running the country, the president and cabinet. Now, when the lawmaker, parliament is the only law. The president does not make laws. Courts don't make laws except through case law. Laws are made daily as people, interpretations come. But the lawmaker is parliament. When the lawmaker says your recommendations are necessary, and you threaten to take them to a court, and while you're doing that, you surround yourself with Remy Kulen, Mosason, and Dube, and all those other people, and they are pursuing an agenda which the lawmaker already says there is not case enough. It's not case enough to amend the act. Where does that leave you? Okay? So that's why she threatened to take them to court, but we don't know how far that went. And thirdly, the legislature, the lawmaker, parliament says, but not only are your recommendations unworkable and unnecessary, your recommendations are unconstitutional. They are trampling on the constitutional rights of the religious sector. And a lot of people say, no, but then the religious rights are not limitless. Neither is any right. But in the Prince case, the judiciary, the Constitutional Court has already defined what the limits for that is. The Constitutional Court ruled in the Prince case that it would never matter how bizarre, how strange, how unusual, or how uncharacteristic any religious practice or belief was, as long as it meets these three criteria, as long as it's not unlawful, it's not illegal or harmful, nobody can tamper with that. So the limit people are calling for has already been defined by the Constitutional Court. Anything that we do, however bizarre, however uncharacteristic, however strange it is, as long as there's nothing unlawful or illegal or harmful happening there. And that is why when we took the doomed preacher to court, he was convicted because even though nothing, there was no regulation in place, there was enough mechanism to deal with that case, and it was found to be harmful. It's an insecticide in people's eyes and all other orifices. So the law is very clear on the extent of limit there is over any practice. So I wanted to bring that to you today, that don't forget, we are not the guys fighting for the amendment of the Constitution. We are not the guys fighting for the amendment of the law. We are not the guys coming with unnecessary and unworkable solutions. The Anti-Regulation of Religion Summit is in line with what the courts think about religion, is in line with what the lawmakers think about religion. And recently, when the leader of the executive, the president there are three legs to the state: the executive, which is cabinet, there is the legislature, which is parliament, and there is the judiciary, which is the courts. And we know presiding over the judicial system is a constitutional court. So the Anti-Regulation of Religion Summit agenda is congruent with all three layers of the state's understanding, because recently the head of the cabinet, the executive, said, no, what you're trying to make us do with religion is a violation of the constitutional rights. So basically, if you are undecided between the support you have for the regulation or anti-regulation of religion, and you wanted to align yourself to what the state thinks about it, we are the guys you should follow. We are saying no to the regulation of religion. We are saying no to tampering with the freedom not only of religion, of association, of conscience. Togo Tladuva and company's recommendations are taking away our freedom of association. They're forcing us into umbrella bodies. They're forcing us into peer review structures. And according to the Constitution, I don't even have to be organized to be recognized. Let's meet on the 27th of April in Klerksdorp as we take this process further. We said we want to give you an international perspective, a legal context, and we want to take you through the journey. We want people to hear us out. As for Ray Mosa and Company, shame on them. As for the ex-commissioner of the civil rights, as for the commissioner, if they bring those clowns back, we will be the ones taking the matter to court. May the Lord greatly bless and keep you. See you in Klerksdorp on the 27th of April.